Hello, boys and girls. Okay, so what's all this business about the Spanish system of obligatory heirs? I keep hearing that in Spain, Spanish people can't actually leave their assets to their spouse. They have children, they have to leave things to their children. And how does it affect me? I live in Spain and I have an asset in Spain. I don't want to leave things to the kids. I want to leave everything to my spouse, and then she can then, as a second step, leave it down to the children, but not in the first step. Or even worse, it could be that you've got children from a first marriage, and now you're actually a second wife, and she doesn't like the children, they don't get on, and you definitely don't want to leave things to the children and leave your second wife trapped having to agree with them on the sale of the property and things like that. Okay, so let me just clarify the situation. Yeah, these things are true, but they've got a very easy solution. Okay, so yes, it's true. Spanish people have to leave 2/3 of the estate down to the kids. And if you are a resident in Spain and don't make a Spanish will, doing what I'm going to say now, then your inheritance will be subject to those same limitations. Okay, how do you solution it? Well, the EU that a lot of people have had so many problems with, they do some good things. One of them was they created this thing called Directive 650/2012, which solutioned this problem of obligatory heirs. This system of obligatory heirs that protects children versus spouse is actually very normal in the southern countries. So we've got basically, with system of obligatory heirs, France, Portugal, Spain, and Greece. Okay, so the 4 countries where all the people from the north go to retire to, they retire to these places, sometimes die in these countries. They were then facing this problem of claims from the children, from obligatory heirs, etc. It was causing a lot of uncertainty, a lot of litigation between children and parents, especially children from other marriages against dad's second wife or mum's second husband. And it was turning into a bit of a legal matter. It was very good for lawyers. We handle lots of these obligatory heir claims, and that is now disappearing as a source of business. It's bad for us, but the solution the EU came up is very good for legal security for people that want to retire in these countries, and that's why they did it. So what does this Directive 62/2012 say? Okay, so basically they come out with these rules, and they said any country that wants to ratify this, they can ratify it, and it will become valid in their country to determine which legislation is applicable, regardless of reciprocity. So it doesn't matter if England later on, Britain didn't later on join, sorry, they've now left the EU. The fact they didn't join this directive anyway, they didn't agree with it, didn't ratify it, it doesn't matter. Spain's going to apply these rules. What do these rules say? Well, there's 2, the actual directive is really, really long, but there are 2 articles that contain what's important for us today. One of them says that if you move to Spain and you're a national of another country, you can make a will in Spain and say on it that conforming to Directive 650/2012, I choose my national law to be known. And this says, you wouldn't say British law, because within Britain, you've got different inheritance laws in England, Scotland, there's different laws. So you'd say British nationality, but that the law that you choose is English law, to determine that you choose English law, your national law, to determine how you are allowed to distribute your estate. And then you can go on to do what you wanted to do. For example, leave everything to your spouse, and then as a second step down to your children. There'd be no problem whatsoever. You make the will that way, no problem. This directive exists since 2012, and it stopped all litigation in its tracks because it creates security. You make the choice, that's the end of the story. Now, if you don't make the express choice of law written into the Spanish will, then what happens? Well, then the other article that's important says that if you have not made an express choice of law, what the law that will apply to your inheritance will be the law of your last residence. So if you are a resident here in Spain and you've got a will that does not make the express choice of English law, you can jump up and down. Well, the spouse that has to inherit can jump up and down and get very angry, but he or she will be subject to the Spanish system of obligatory heirs. So even if their husband said that they wanted her or him to inherit the villa completely, the first step, then that will is going to be partially invalid. because it has to be, it's affected by the Spanish system of obligatory heirs, which means that just under 2/3 of the estate of the deceased would have to go directly down towards the children. So yes, it's a problem if you don't do it correctly, but if you do it correctly, you make your will, you make the choice of law, there is no problem whatsoever. A little problem that has arisen recently, and we're starting to see now, is for those few that when Brexit came along decided to become Spanish nationals, they will have realized, because it will have been explained to them, that Spain does not accept double nationality with Britain. I don't know if you're guessing where this is going to go, but as far as, even though in the UK they may find that they've still got their passport and England still considers them British, but as far as Spain is concerned, they are now only Spanish nationals. So of course, what happens next? Well, that will, where they made a choice of their English national law to determine how good state is no longer valid, because they cannot choose their national law and say it's English law, because as far as Spain is concerned, they are now only Spanish. So yes, for those people that have become Spanish nationals, there's not many of you, so therefore doesn't affect too many people. You cannot escape the Spanish system of obligatory heirs. It's not possible. So even if you want to leave everything to your spouse, if you have children, you can't do it, because now you are a Spanish national and you are subject to the same limitations as any other national here in Spain. I hope you found the video useful. If you did, please hit the subscribe button. If you need help with wills or inheritance, contact us via the website, and we can help you regardless of where you are in Spain. We can do the consultations at one of our offices. We've got 3 offices here in Andalusia, but if you're not in the area, you don't live in this region, or you're in another country, we can have a Zoom consultation and work out how to prepare a good will for you and how to deal with your estate. Thank you for watching.